Commissioner C, Commissioner McBride, and Chairman Johnston.
Oh, pardon me. Are there any additions or corrections, amendments to the agenda?
No, that's not.
Do we need a motion on that to accept the agenda, or?
If you would, please.
Okay. Do I have a motion to accept the agenda as submitted? Moved and seconded. No objection. Agenda is approved. Approval of the minutes of April 17th. Any additions or corrections?
I've reviewed them and don't have any amendments and move their approval.
Okay. Moved and seconded. If there's no objection, the minutes will stand approved. Commission member comments. Are there any comments? Other than that you're pleased that I managed to get here on time. Okay. Let's go to the informational agenda. And we have a receive and file judgment on the dismissal regarding litigation, Ventura County Republican Central Committee versus the County of Ventura and the Ventura County Campaign Finance Ethics Committee. Do we need any discussion on that, or is that just a motion for receive and file, Roberta? Or do you?
Yes.
Okay.
I've got a question. I don't want to prolong this. When people form a committee, they're given I assume they're given all of the proper finance rules and regulations. Do they sign anything to indicate that they've received it, that they've read the materials? I mean, I know this is.
Not that I'm aware.
No.
The candidates have to. They have to sign papers when they take out their candidacy papers, but the treasurers usually sign the first filing, but they don't have to. The candidate can sign as treasurer.
Okay. The election
I'm not aware. In this case, this was a lawsuit, if you don't already know, about the attorney's fees after the complaint was not carried through to a resolution against the committee, and they lost in court, and eventually this was judgment.
I guess my question probably goes more to the next item.
Oh.
Maybe that's.
Do these committees have to take something out, or can they just form and then they're required to file a report after?
The committees, after they get $1,000, have to do certain filings that both the state and the county require.
Okay, but it's a filing of the report that they've done it as opposed to getting certified in advance?
It's mostly filings to report contributions and expenses and expenditures.
Okay. So that could be potentially after the fact. That they've
Oh, it's always after the fact, although when it gets close to election, some things are due overnight mailed and within 24 hours.
Yeah. Okay, on the informational item of receive and file, do I have a motion?
I move the recommended action.
Okay, moved and seconded. No objection? Okay. Next item, the regular agenda. There's a recommendation to approve stipulation decision on the order for cases number 2006-04 and 2006-05, Ventura County citizens for a full-time supervisor, and Leonard Paulin, treasurer, by investigator Craig Steele.
Our investigating attorney, Craig Steele, is here to present this item.
Good morning, Mr. Chairman, members of the Commission. It's a pleasure to be before you, I think, for the first time with this Commission. This proposed stipulation resolves two identical complaints about the same activity. In May of 2006, immediately prior to the June election, this committee formed, collected 7 contributions, 6 of which were $1,300. The 7th was $2,500. Took that approximately $10,000 and made an independent expenditure on behalf of a later unsuccessful candidate for the Board of Supervisors. The ordinance at that time prohibited an independent expenditure such as this one from being made from an account that had collected contributions in excess of the county's contribution limit. Because those contributions, those 7 contributions exceeded the $600 limit, this committee could not have legally made that independent expenditure from that account. The committee contends that were not aware of the applicability of the ordinance to an independent expenditure committee. Indeed, there is some, there has always been some question in campaign finance law about the applicability of regulations to independent expenditure committees. But in this case, it was very clear that the county's ordinance prohibited this type of expenditure being made from this type of account. The committee did not try to hide any of these contributions or anything like that. They timely filed the reports, and the reports on their face indicated the violation. We have agreed to a stipulated resolution of this matter with a fine of $700, which represents $100 per contribution that exceeds the limit. And, pardon me, I'm a little bit under the weather today. We agreed to that stipulation. County Council suggested a revision to the stipulation. That revision is in the document before you. I did send it up to attorneys for the respondent, and unfortunately, through some miscommunication, the respondent treasurer, Mr. Paulin, left the country prior to signing the stipulation. I received a message from council on Monday asking for an extension until July 17th to return the signed stipulation to us. They reiterated that they want to resolve this matter, and they agreed to the stipulation, but Mr. Paulin is in Turkey until July 17th and neglected to sign the document before he left. So I think there are two options for the commission. Unfortunately, we didn't know this when we put the matter on the agenda for today. We didn't know that we wouldn't have the document at the time of the meeting. I think there are two options. One is to simply continue the matter until after July the 17th. That would obviously require scheduling another meeting in the summertime. The second I would suggest is that the commission could approve the stipulation with the condition that it be received, signed with the check, say 1 week after July 17th, or the matter would be set for hearing, and I'll leave that to your discretion. I'm happy to come back with the signed document once we have it, or take it with an extension. And I'll be happy to answer any questions.
Are there any questions?
I couldn't tell from the statement of facts when the contributions themselves were made. Was it on May 30th?
They were all on May 30th.
And the report was filed May 31st?
Yes.
And the first complaint by the election division was filed on the 31st?
Yes.
And Ms. Michaels' committee was filed when?
I believe it was the day after, or I believe it was June 2nd was the date of the second complaint.
And there's no indication that there was any communication between either the election division or Judy Michaels' committee and the independent committee before the contributions were made?
Not before the contributions were made. There was communication between elections and this committee after the report was filed.
After the report was filed?
Yes, because the report indicated obviously that there had the contributions had exceeded the limit.
I don't have anything further.
Jim?
Kind of back to my first question. Doesn't that work?
You were technically challenged.
Kind of back. I mean, I have no problem with the $700, $100 a piece. I mean, assuming that as is stated here that they were really ignorant of what they were supposed to be doing. But does this set a precedent in some fashion that anybody can do the same thing and will get a slap on the wrist? I mean, the cost to the county is a heck of a lot more than $700 to get to where we are. And at some point, the rules have to have teeth in them. Is the intent that this is the first step in putting teeth in these rules? Because this doesn't make sense to have rules and have the county spend probably $2,000 or $3,000 to get a $700 payment out of this, and then these people are gone anyway, and you deal with the next one.
Well, I obviously can only give you my perspective and can't speak to the policy issue of it, but I will tell you that having experience with a number of new campaign finance laws in different entities, there's always a sort of ramping up an education process that takes place in the first election or two after the ordinance is adopted. And we are talking about the first election that the ordinance was in effect for. And so the $100 per count in this case is sort of an education factor and a little bit of a deterrent, because it shows that we have some teeth, but we are being a little bit more lenient because it was the first time through this ordinance's enforcement. If this particular treasurer comes along again on the enforcement radar, you can be sure that the penalties would be much more steep, because we've had enforcement experience with this particular treasurer now.
Well, how about somebody else? Another committee, another treasurer. They do the same thing at $20,000, $10,000, whatever it is, and they take a look and they say, look, we're only going to get slapped with $100 a piece.
Well, I wouldn't think that in subsequent elections after the first one, I would not think that you would be limiting the fines to $100 per piece. I think we've been through 2 elections now with the restrictions in place, and I would think penalties would be more severe as you get more used to dealing with the ordinance. That's certainly been the case in Los Angeles and other jurisdictions that
How
have
does
started.
the word get out of these rules?
Well, the regulated community, the treasurers, the candidates certainly know what happens in these cases, and the attorneys that represent these groups know what happens in these cases, and that discussion is had among that community.
I had the same concern when I read that, because obviously the $700 in itself is not truly a deterrent in relationship to the amount of money and what was done. I mean, if you look at the timing on the thing, we used to refer to those as sort of hit pieces when you gathered in the back room and sent out a flyer and said who's going to pay for it, and then you passed the hat. But I agree with the idea that when this was new and we're ramping up, is it possible that we read something into the record that indicates that while in this set of circumstances, and both the newness of the ordinance and the factual situation, that it was the $100 fine, but that in no way should be read by anyone as a precedent that in the future, or is that just wasting words?
No, I think that's good guidance, especially for myself and the other attorneys that would handle these cases as you go along. And I would say, just in addition to what I've already said, if this was a case where the contributions had not been reported or had been reported in another name, or they tried to make it look like they were legal contributions, for example, I would view this case a whole lot differently. But since they timely filed a report, and on the face of the report showed that they violated the law, I tend to think that this is a case of ignorance of a new law and not something more sinister than that. And of course, the candidate that was supported evidently didn't benefit from the expenditure. So those 3 factors, I think, indicate that a little bit more leniency is warranted in this particular instance. There was some discussion, and this is going back a couple of years with the prior commission, about standardizing sort of levels of initial fines, or what kind of circumstances would warrant lower fines versus higher fines, and that might be something that the commission wants to memorialize in some kind of regulation.
I guess my concern is the risk-reward calculation that is done by, I won't say cold-hearted people, but dispassionate people in the, if this is not an oxymoron, in the heat of a campaign, and that is they say, well, what's the worst that can happen to us, okay? We used to refer to it as the Jesuit law of take action and ask for forgiveness or permission later. I don't think in this particular instance that necessarily applies, but I think in future instances, if someone read this record and we didn't make it clear, one would say, just as on paying our property taxes, there was a time when the property tax penalty was, 6% or something for being late, and you were making 7 and 8% on CDs back in the 80s, and so it was real easy to say, well, we'll go delinquent and we'll make 2% on the float or the arbitrage. So anyway, that is my concern. I'm not overly concerned with the amount of money involved at this particular junction.
And I do think that you know, as always, when we start these cases, we remind the other side, and you know, really the way we get them to the table is that the fine, the maximum fine that the ordinance allows, if it was to go to hearing and the commission was going to impose the maximum fine, is 3 times that amount that was improperly reported or improperly contributed. So that number is always out there, and you start with that number as sort of the threat, and I think that threat remains. But in the case of you know, this, where the violation was sort of admitted at the time it happened and the respondent was cooperative, it seems to me it's more of an education process than anything else.
I'd like your views on what would happen in the campaign finance community if we imposed a $10,000 or $18,000 fine in this case.
Well,
I know the process. They're going to be hearing a lot of other things, but what's the ripple effect out in the community?
Well, I don't know for sure. You know, I do a lot of work with the city of Los Angeles, and I don't know that the city of LA has ever imposed a maximum fine in all the years of their ethics commission. So I can't give you anything from experience. I think in you know, 75 or 80% of the cases that I see, you're talking about situations where people just in the heat of the battle said, let's do this, and didn't really know what the law said. And so you've got amateurs, if you will, sort of inserting themselves into the political process late in the game without really knowing the fairly complex regulations you have in place. And so you have, those people are generally making mistakes. The big shots generally know what the rules are. And it wouldn't affect the big shots because they would comply with the rules and find ways to do what they needed to do. It would affect people like this who got mad about something for some reason or another and decided to send out a mailer late in the game and didn't really know that they were violating the law. So I think as a policy matter, you want to reserve maximum fines for cases like money laundering, which is a very serious violation in jurisdictions that have a limit like you do, where somebody goes out and pays their employees to make a bunch of $600 contributions. That's where you want to impose the maximum fine, where you've got that reimbursement going on, or making contributions in the name of another, because those are the worst kind of violations in your type of regulatory system. And that's where I would, you know, really reserve the hammer and come down hard. I don't think it would be as effective in this case. I don't know how it would get paid in this case, for example. And I'm not sure that it would be the right policy decision in a case where it was just a mistake at the beginning of a new finance system.
So I take it from your dealings with the parties, you're satisfied that this was not a Jeremy Bentham pain pleasure analysis that they undertook before making this expenditure?
No, not at all. They did not know that the ordinance applied to an independent expenditure.
Should we include some kind of statement, or is that necessary?
I think they can get the sense of our concern here. I think that should be conveyed somehow. I don't know how it gets conveyed out into the system, but you know, you've got these rules. They're out there. I guess it keeps the big boys in line. And I guess, you know, I hate the idea of ignorance of the law. It's an excuse, and we don't enforce it. But on the other hand, it seems to me this is a just, in this particular case, this is a decent result. But I do have some concern that you know, the little guys set up their committee, that somehow they know they've got to sit down and read the rules. And I don't know how you get that message out.
One thing I might suggest is, and I don't know, Roberta would know whether this happens already, but perhaps publishing the results of these cases and the fines that have been levied, either on the website or just in a list form for these committees to see that there is enforcement going on and that there is some kind of penalty for violating these ordinances might be effective. I also think that your comments today certainly make it clear to me, and I know Kay would pass it on to the other investigators, that now that we've been through the cycle once, I think this is the last case from the 06 cycle. Cases that come in the future are certainly going to be warrant much more serious enforcement action and fines, because everybody's been through the cycle a couple of times now. And I certainly take that message from your comments today.
Thank you.
And my concern, one, was the precedent, but not in this particular case. I mean, I could support this on the basis that it was new and that the circumstances give the appearance, at least, that it wasn't kind of conspiratorial or any kind of, you know, subversion of the law. But on the other hand, there is a practical aspect of the cost to go through, you know, for you to look into it, for us to sit here, and for the county. So I guess I would hope that the record would show, I will support the motion, but that in the future, that if it is found that there's a violation of the ordinance, at the very least, that the county will recover its costs, and then we'll go from there up. Any other
I'd make
discussion?
that a motion.
Really? Okay.
Approved with an additional condition that the stipulation be approved as it is, subject to the signing and the payment by August 1st.
I would just note that if we did proceed to hearing, there's no way that the county would recover its costs on an $18,300 fine. So perhaps that motion is unrealistic given the limits of the ordinance itself. If the motion was to assure that in the future the county recovers its costs. Or something close to it.
Is the idea that would be in, that any of these stipulated decisions you'd recover that initial cost? The hearing, you're probably not going to recover its cost.
Well, I think the message in that case would be clear, that if it goes to hearing, that that they have a stop loss on what they're going to pay, but they'll get the maximum fine. So I don't know how you would word that, or if you need to even include that in the motion.
I'll second the motion as stated.
Okay.
Let it
You want
float
the-
out there.
Okay.
Aye.
Okay, moved and seconded. Do you want the motion read back, or? The clerk saying, what did they say?
What did you say?
It looks like the old days, making it up on the fly. Okay, so what are the salient points of the motion?
But the salient points of the motion are that we approve the stipulation, that it is subject to the signing and the payment by August 1st, and that in the future, that maybe we make it, every consideration be given to the county recovering its costs.
Okay,
Fine.
okay, move to second. Any objection to the motion? If not, motion carries. Thank you, sir.
Thank you.
Okay, where are we? We're
That's
on.
because of our high salaries.
Yeah, right. Item number 8, adoption of commission forms for subpoenas. Civil subpoena for personal appearances at trial, and civil subpoena duces tecum for personal appearances and production of documents. Do we have any discussion on that? Robert?
Sure, I'd like to make some comments. Under the ordinance, section 1297H, your commission is given the power and authority to issue subpoenas and to establish the procedures for issuing subpoenas and to delegate to the chair of the commission, the investigating attorney, and other attorneys involved in the matters before the commission the power and authority to issue the subpoenas. This was pointed out to you at your last meeting, at which time I suggested I would bring forth some forms based on what the Civil Service Commission uses. And they basically use the court forms with areas filled out for the commission instead of, obviously, for a court hearing. Under your operating policies and procedures that you adopted at the last meeting, under section 306 C3, it says there that you shall establish the procedures for issuing subpoenas, and under 1306, which is found on page 11 of your operating policies, you establish this procedure. Before an evidentiary hearing has commenced, the chair or the investigating attorney may issue subpoenas, and subpoenas ducas tecum at the request of any party for a witness attendance or production of documents at the hearing. Compliance with the provisions of section 1985 of the Code of Civil Procedure shall be a condition precedent to the issuance of a subpoena, and that includes, of course, the witness being entitled to fees and the proper showing of good cause made for any documents being required. And after the policy continues, after the evidentiary hearing has commenced, the chair may issue subpoenas, and subpoenas ducas tecum. All costs related to the subpoena, including witness and mileage fees, shall be borne by the party requesting the subpoena. And that references ordinance, again, section 1297H. I brought these two forms forward, have only one minor suggestion to change to them, and that is in the request for accommodation section that you have the clerk type in at the end, submit the form to the clerk of the board, so that people aren't submitting forms to the Superior Court and the Superior Court wondering why they're getting these forms. Otherwise, they could be modified as needed, and currently, under section 1306, the only persons authorized to sign them are the chair or the investigating attorney. So you would have to change your policy if you wanted to allow all attorneys to sign it. Under the Code of Civil Procedure, of course, any attorney as an officer of the court can sign the subpoena. But as is done with the Civil Service Commission, to monitor what's going on, and because normal discovery rules do not apply, it's my suggestion that you keep it limited as currently. And your pleasure on what else or other changes you would want made in the form. Obviously, these are court forms, but rather than get in the system and muck them up, with, you know, they're difficult to work with, the Civil Service Commission has worked sufficiently for years with just using the court forms and typing in where the hearing is and the name of the commission.
Do I find the term muck them up in Black's dictionary, or is that one that?
Pardon me?
I said, do we find the term muck them up in Black's dictionary, or is that one that I would normally be familiar with?
Latin.
Yeah. Okay. Do we have a motion to accept the forms with a suggested addition of filing with the clerk of the board?
So moved.
Moved.
Second.
Moved and seconded. Any discussion? If not,
Just one question subsequent. I take it that all administrative subpoenas you're familiar with contain the language court in the disobedience section and in the caption and so forth, even though this is not a court, strictly speaking.
That gets back to the point of altering the form. I wondered about that when I first started doing hearings before the Civil Service Commission, and I think it's just for ease and convenience, and as long as the commission is named, and other commissions besides Civil Service have used this form, and of course attorneys use them even when the hearing is going to be at their own offices, that hasn't presented a major issue of confusion or concern. The accommodation thing stuck out at me because it's fairly new, and because it directs you to a particular court form. I didn't want people to think they had to file anything in Superior Court.
Good.
okay, any other?
Oh, and one final comment. It does say in the question section, point 2 on the first form, for example, it gives you a direction as to who to contact. So that can always be a person who's familiar with the proceeding. It would tell people, you know, you're not going to court, you're going to the Hall Administration, and it's on this date, and if you have any other concerns, you work them out with me or the other attorney, the investigating attorney, or the other party's attorney.
Any other comments or questions? Okay, if not, no objection to the motion is stated? Motion carries. Okay, we are at item number 9, public comment. Time set aside for citizens presenting presentations regarding campaign ethics commission related matters not appearing on the regular agenda. Do we have anyone present who would like to address the commission? No? Yeah. Well, my best wishes to Caroline and Abstentia. Okay, if there's no further business to come before the commission, we stand adjourned. But what about our next meeting? Okay, well, we had a nice phrase in the last set of minutes that said you could set it up based on need. Is that?
I think that worked last time. I think,
Okay, unless you have something that you
Okay.
know is coming up.
no, we don't have anything at this time.
Okay. Okay, so we will adjourn with a meeting to be called as needed. Okay? We're done. Thank you.